Welcome back to the Constitutional Clarion. Following on from my last video about the power of the Commonwealth to build and operate nuclear power plants, a number of people, including viewers on this channel, have asked me about how it is that litigation has been used to defeat the building of nuclear waste storage facilities in South Australia and the Northern Territory. It's a good question, and the answer itself is actually quite interesting. This video will look at how, even when there is constitutional power to do something, it can still be thwarted by litigation because of defects in the government's decision-making processes and its inability to get Parliament to change existing laws to remove consultation requirements or other fairness features that are required for that government decision-making process. In 2003, the Howard Coalition government decided that it would establish a national storage facility for low-level nuclear waste in South Australia. Now, this is largely waste from nuclear medicine for cancer treatment and waste coming from the Lucas Heights nuclear reactor in New South Wales, which is used for both nuclear medicine and for scientific research. The government shortlisted 2 sites in South Australia near Woomera. The South Australian Labor government at the time opposed the proposal. It announced that it would legislate to turn the 2 sites into public parks. Now, how would that help, you ask yourself? Well, Section 51(31) of the Commonwealth Constitution allows the Commonwealth Parliament to legislate for the compulsory acquisition of land from a state with just terms compensation. Now, that legislation that the Commonwealth has enacted to do this is called the Lands Acquisition Act 1989. However, Section 42 of that Act says that the Minister may not make a declaration compulsorily acquiring any land that is in a public park unless the government of the state or territory in which the land is situated has consented. Okay, now you understand why this land was going to be turned into a public park. Now, this of course could be remedied if the Commonwealth Parliament repealed this provision to allow the compulsory acquisition of public parks. But getting that through the Senate might well be a difficult feat because of course it would have other ramifications. So the Commonwealth used another provision of the Act, an urgency provision, to try to complete the compulsory acquisition quickly before the South Australian Parliament could legislate to turn these sites into public parks. According to the Commonwealth legislation, the Minister had to be satisfied that there was an urgent necessity for the acquisition and it would be contrary to the public interest for the acquisition to be delayed by undertaking the normal processes under the Act. South Australia then challenged the use of the urgency provisions in the case of South Australia and Slipper. It lost at first instance in the Federal Court, but it won on appeal. The full Federal Court unanimously agreed that it was not open to the Minister in the circumstances to be satisfied that there was an urgent necessity for the acquisition or that it could be contrary to the public interest for the acquisition to be delayed. The desire to avoid the land becoming a public park was not a factor that could constitute an urgent necessity for its acquisition, nor could it be regarded as contrary to the public interest for Section 42 of the Commonwealth Act to actually operate. The court pointed out that if the Commonwealth was frustrated by the operation of Section 42 in preventing it from compulsorily acquiring land in public parks, then it should ask Parliament to amend or repeal Section 42. The court also held that the Commonwealth had failed to follow all the necessary steps for an urgent acquisition as set out in the legislation, resulting in a denial of procedural fairness. For both reasons, the court set aside the acquisition. the Commonwealth Government did not appeal and it abandoned its planned national storage site for South Australia. Instead, it later planned to store nuclear waste at the Muckaty Station in the Northern Territory, which should have been much easier because, of course, the Commonwealth has full legislative power in relation to territories in section 122 of the Constitution. However, the relevant Commonwealth statute required the prior consultation and consent of traditional owners of the relevant land. A challenge was brought on the basis that only one group of the traditional owners had been consulted, neglecting the others. In the course of the litigation, before it had even been resolved, the nomination of Muckaty Station as a site for a nuclear storage facility was withdrawn. Again, if the legislation had been different, this would not have been a problem. But this would mean convincing the Senate to exclude consultation with traditional owners in such circumstances, which again is a matter of politics. Next, the Commonwealth returned to the idea of placing a radioactive waste management facility in South Australia. In November 2021, under the coalition Morrison government, the Minister for Resources, Keith Pitt, declared that a site in the Eyre Peninsula was to be a facility to store low and medium level nuclear waste and the land compulsorily acquired for this purpose. Now, this was challenged by the Bangala traditional owners in a case called Bangala Determination Aboriginal Corporation and the Minister for Resources. Part of the challenge was directed to the constitutional validity of the National Radioactive Waste Management Act 2012. It failed. The law was upheld as a law with respect to external affairs and defence, so it did have heads of power in the Constitution that supported the law, as explored in my previous video. Section 24 of the Act also specifically displaced certain state laws to the extent that they would regulate, hinder or prevent the construction or operation of the waste facility. This includes state laws concerning land use, the environment, heritage, and the transportation of radioactive material. These state laws would have no effect with respect to the operation of the facility or the transportation of radioactive material to and from the facility. As I explained in my previous video, this is because of the operation of Section 109 of the Commonwealth Constitution. Because of this, no challenge was actually brought on the ground that the facility would breach state laws. But a challenge was brought to the decision-making process of the minister, and it was successful on the ground of apprehended bias based upon apparent prejudgment by the minister before he exercised his power of declaring the site to be a nuclear waste facility. The test for apprehended bias is whether a fair-minded lay observer might reasonably apprehend that a decision maker might not bring an impartial mind to the resolution of the issues to be decided. The Federal Court accepted that the fair-minded lay observer might apprehend from statements made by Minister Pitt that he might approach the exercise of the power with a foreclosed mind because his statements strongly conveyed the impression that his mind was made up well before he undertook the statutory decision-making process. The court ordered that the minister's decision be set aside on the grounds of apprehended bias. One aspect of the apprehension of bias was the minister's support for legislation which, amongst other things, would directly acquire the land and avoid the ministerial decision-making process at all, and would also avoid any prospect of judicial review. But the legislation was only passed after the provisions regarding direct legislative acquisition were removed and the existing process of government decision-making, including consultation, was preserved. Again, the issue here was a political one rather than a constitutional one. By the time the decision was handed down by the full federal court in July 2023, the Albanese Labor government was in office. It decided not to appeal the decision. The Resources Minister, Madeleine King, said that the government did not intend to pursue this site for a nuclear waste facility. The minister, in a statement made on the 10th of August 2023, said that her visit to the area had shown that the residents of the nearest town were divided on the issue and that a radioactive waste facility requires broad community support. Now, what does all this tell us? Even if the Commonwealth has the constitutional power to make laws with respect to a subject and to override any state laws with respect to that subject, it can still face litigation and lose. This is because, for the most part, the laws made by the Commonwealth will confer decision-making powers on ministers or other officials. Those powers must be exercised in a fair manner. This means that there can be no bias, they cannot be exercised for an improper purpose, the minister must only take into account relevant considerations, not irrelevant ones, and there must be procedural fairness. Now, it's here that government decision-making is most vulnerable to litigation. When decisions are rushed or made with disregard to necessary procedures for political reasons, they will fail when they're challenged. Ministers are politicians and are often therefore impatient with following the rules, which they see as unnecessary red tape. When public servants advise them about what they need to do and the formal steps they have to take, ministers often reject this as obstruction. Ministers are also inclined to announce positions in the media before going through the proper processes. But the public servants, hopefully, are acquainted with how administrative law applies and the requirements of the relevant legislation, and are advising the ministers to follow the rules not to be obstructive, but to actually get the job done validly and effectively. The other point to make here is that the legislation itself often sets out procedures to ensure that there's consultation and fairness. When looked at objectively outside the particular political goal that's at issue, it makes sense to engage in consultation when compulsorily acquiring property, and it's important to follow administrative and safety procedures in dealing with dangerous radioactive materials. But this does slow down the decision-making process, as frustrating as that may be. Of course, in most cases, these processes can be dispensed of by legislation. In all the cases mentioned here, the Parliament could have resolved the issue by changing the law. But in some cases, it was just not politically feasible because any such change would have wider ramifications, including future impacts on other groups in the community. So while there may be sufficient constitutional power for the Commonwealth to establish and operate nuclear power stations in Australia, the history of attempts to establish nuclear waste storage facilities shows that governments need more than power. They need the discipline and the time to implement fair decision-making processes, or they need to be able to persuade Parliament to enact laws that would override those processes. Thank you once again for watching the Constitutional Clarion, and as always, I look forward to seeing you again next time. Goodbye.